Hello, everyone. We're going to look at civil liberties today, and we're going to focus on the Bill of Rights and our First Amendment. Last time, when we talked about the Constitution and federalism, we had to understand that the Federalists thought it was unnecessary to have a Bill of Rights. If it weren't for the Anti-Federalist and James Madison, we wouldn't have a Bill of Rights in our Constitution. The Bill of Rights applied at that time in the early stages of our nation's history to only the protections that individuals had against the national government. And these are our Bill of Rights. Of course, they're the first 10 amendments to the Constitution. After the Civil War, we used something called Selective Incorporation, where we applied the Bill of Rights to the states as well. So no longer were they protections against the federal government, but they were also protections against your state government too. One aspect of your First Amendment freedoms is your freedom of religion. When we talk about the freedom of religion, there are two separate clauses. There's the Free Exercise Clause and the Establishment Clause. When we talk about the Free Exercise Clause, you as an individual can practice a faith or not practice a faith. And when we talk about the Establishment Clause, what we're saying is that the national government does not sponsor or promote one religion over another. We do not have a national religion in this country. In order to, let's say, evaluate the Establishment Clause, what we do is apply something called the Lemon Test. Any law that is created must pass three separate criteria. We get the idea of the Lemon Test from the case of Lemon versus Kurtzman. All laws must have a secular purpose. They must have a primary effect that neither advances or nor inhibits a religion, and it must not foster excessive government entanglement with religion. That last one, excessive entanglement, could mean anything these days. The difference between religion and speech is that we have pretty much a clear-cut definition of what our freedom of religion is all about, but when it comes to speech, there are various forms of speech that we protect and we don't protect in this country. For example, when it comes to political speech, we do have legitimate questions about what is political speech, but in the past we used something called the clear and present danger test, or the bad tendency test, that prohibited certain types of political speech. Campaign speech is basically a free-for-all these days. We pretty much can put any political ad on television or the radio or the internet, and it doesn't have to be true in order for it to be broadcasted. Also, we've said that any form of political contributions to a candidate and political spending is a form of campaign speech. So in this case, campaign speech is protected under the law. Commercial speech is not protected because we're dealing with products, and you can't make false claims about something that you're trying to sell. With symbolic speech, we do protect, let's say, our flag burning that takes place in the United States as a form of protest, or in this case, it would be called a form of symbolic speech. So that would be worthy of First Amendment protections. However, commercial speech, as I mentioned before, is not protected. Obscenity is not protected, but it's pretty difficult to enforce obscenity laws in this country. We use something called the Miller test, which comes from the Supreme Court case in 1973 of Miller versus California. And in order for something to be defined as obscene or dealing with obscenity, it has to involve those three questions. Defamation, we always hear the statement, libel is written and slander is spoken. We use something called the Sullivan Rule to define what is actually slanderous or libelous in this country. In order for you to, as a defendant, to claim that you've been libeled or defamed, your character has been defamed, You have to prove that the statements that were written about you were knowingly written as a falsehood, and that you have to talk about how this disregard for the falseness affected your everyday life. So in this case here, it's very difficult to prove libel. Hate speech is one of those things where we kind of throw it up in the air. We've left it to communities and college campuses to ban hate speech. The Supreme Court really doesn't get involved in hate speech activities. When it comes to the freedom of the press, we have to understand that we do not like the idea of censorship in this country. Traditionally, radio and television have not been as free from government control as the print media. That is true. You do have licensing involved with radio and television. I used to work in radio myself, and I had to have an FCC or a Federal Communications Commission license to broadcast. There are no government regulations on print media. And in terms of association and assembly, part of our First Amendment as well, we do understand that we do have the right to assemble, but local governments basically set up the time, place, and the restrictions, the manner restrictions that you need in order to get that permit to assemble. So, for example, if you wanted to march down the main street of your town in the middle of rush hour, you could do that, but you're going to be restricted from doing so and probably arrested. But if you asked for a permit to march in the middle of the downtown, let's say at rush hour, that local community is probably going to tell you no, but they'll give you the permit to march, let's say, on a Saturday in the middle of a park. It's 8 o'clock in the morning, and it's essentially take it or leave it. So yes, you do have the right to assemble and the right to associate, but in terms of protesting and marching, you do need a permit to do so. And that's left up to the local governments to hand out that permit.